What are the facts of which you are aware that support your claim that my client was conducting illegal surveillance of you?
Objection, honey. Overly broad and vague. The term facts is something that this witness cannot possibly detail everything she knows about the bus company videotaping her.
I find your question confusing. I just don't know how to answer it.
Objection, honey. Overly broad, vague. It's not overly broad and vague. But the witness, you notice what her answer was? I don't understand. That means she's been coached before the deposition, when I say overly broad and vague, to not answer the question and say she doesn't understand. Even those lawyers that are in between those two groups I defined will use at times to try and signal to their clients, this is important, you better listen to this question and listen to my objection because I'm telling you something in it. That's wrong. And federal rule finally, in the 1993 amendments, put something in the rules to stop that practice. The problem is, we don't teach it in law school, so most young lawyers don't learn it until they've been burned. She can't possibly tell you everything. She can tell you about the event in which a camcorder outside her home was pointed in her direction.
Now, counsel, stop right there. Now, Federal Rule of Civil Procedure 30 precludes you from making objections that are argumentative, harassing, or suggest an answer to the witness. Now, counsel, your objections are obviously argumentative, extremely harassing, and you've been suggesting to your client not only not to answer my questions, but in this last objection, you actually gave her specifics as to how to answer my question. Now, counsel, that's entirely inappropriate.
And I will continue to make objections to zealously represent my client.
Well, then, I'm simply going to have to call the court and relate what has been going on here today, and to make a motion precluding you from making objections inconsistent with Federal Rule of Civil Procedure 30.
Good morning, clerk's office. This is Drew Page. How may I help you?
Yes, sir. I'm defense counsel in a case pending in your court. We are in a deposition and we need a ruling on matters that have occurred during the deposition. Could you please transfer us to an available judge?
I'll be glad to do so. Judge Michael is available and I will transfer him to you.
Thank you.
A lot of young lawyers are afraid to call the court. And I'm here to tell you, courts get called all the time. They understand that in depositions where there's not a judge to keep people in line, lawyers will misbehave. And so you call the clerk and you say, we're in the middle of a deposition and it's going to create great expense to have to come to court to deal with this matter. Could you please find me a judge that can rule on what's going on at the deposition? And I'm telling you, they'll find a judge. In federal court, it's typical the federal magistrate judges are assigned the job of taking these calls. It's not a big deal to them. So don't be afraid. And I took to depositions after I got burned the first time, the telephone number of the court in which the action was pending. Had to call maybe once or twice. The other times I said, counsel, I've got the number of the court where the case is pending, and I'm willing to call the court if you want to continue with this kind of behavior. Guess what? The other half, the composite of the lawyers that make these kind of objections, call young ladies darling and coach witnesses, will do at that point. They'll back down every time.
What are the facts of which you are aware that support your claim that my client conducted illegal surveillance of you?
I'm not sure of it. I just believe that this big bus company was videotaping without my permission.
But on what do you base that belief?
I'm not sure of it. I just know when I met with Mr. Madison, I realized I must have been videotaped or recorded.
Did you ask Mr. Madison what would be necessary to bring a suit against Big Bus Company under the statute prohibiting videotaping without court approval?
Yes?
What did you discuss?
Mr. Madison said that we need to show that Big Bus Company was either videotaping or electronically recording me without my permission or the court's permission. And he was just looking to see whether someone had been videotaping.
All right, the worst part of the deposition was when I was sleeping. What got waived?
Attorney-client privilege.
Not just the attorney-client privilege, but let's start with that. What did Ms. Dunning ask? She asked about private communications between an attorney and a client, sue a lot, concerning legal advice. So, classic attorney-client privilege should never see the light of day. And that's when I could have objected. And I should have said, objection, attorney-client privilege, and I instruct you not to answer. The one area in a deposition where you can instruct a witness not to answer and a court will never overrule it if it's a legitimate objection. Sometimes they'll hold a hearing on whether it is attorney-client privilege. But courts recognize that invading the attorney-client privilege is serious material, and you can instruct a witness not to answer. And I'll bet you never forget what you just saw.